Welcome to the debate. Today we are taking you inside the Peace Palace in The Hague, where a panel of judges is currently weighing a decision that really challenges the very nature of sovereign immunity and state rhetoric.
Right. We are analyzing the International Criminal Court's confirmation of charges hearing regarding the situation in the Philippines and former President Rodrigo Duterte.
It is a case that sits right on the fault line between international law and domestic politics. The central question we are looking at is whether the former president's bombastic language constitutes a criminal policy of state-sponsored murder or if it is rough political rhetoric protected by the context of governance.
The stakes are incredibly high here. It is important to note this isn't a trial yet. This is a confirmation of charges hearing, which is meant to determine if there are substantial grounds to believe a crime was committed.
Exactly. For the victims, this hearing is essentially the last boat. It is a vital moment in seeking justice, but it is also deeply controversial.
Because for the defense, this entire process is seen as a politically motivated attack on a democratically elected leader.
Well, I will be representing the perspective of the prosecution and the victims today. My position is that the former president's statements were clear expressions of criminal intent. They created this virus of impunity that directly caused mass violence.
And I will be representing the defense's perspective. I will argue that these statements were hyperbole and political rhetoric meant to instill respect for the law. The prosecution has really cherry-picked quotes while ignoring explicit calls for restraint.
Let us get right into it then. The prosecution is relying heavily on the legal theory of the indirect perpetrator. They are not saying the president personally pulled the trigger on the streets of Manila. They're arguing that his words were the engine of a literal killing machine.
But equating political speeches with a killing machine is a massive legal leap.
Is it, though? I mean, we're not talking about vague allusions to being tough on crime. The rhetoric was explicit. The most chilling example in the dossier is the Holocaust comparison. The president explicitly said, and I quote, "Hitler massacred 3 million Jews. There are 3 million drug addicts. I'd be happy to slaughter them."
Right. That is a highly inflammatory quote.
It is more than inflammatory. Pause on the word choice there. He did not say arrest them. He did not say rehabilitate them. He said slaughter. The prosecution argues this is an admission of intent to commit a crime against humanity. It created a reality where these words metastasized. It created Duterte clones and mini Dutertes across the country who believed violence was a perfectly valid administrative solution.
I hear the prosecution's interpretation, but you really have to understand the unique phenomenon of his leadership. He was not speaking to an international panel of judges in a sanitized courtroom. He was speaking from the heart to a Filipino populace that was completely tired of elite oppression and terrified of a narco-state.
But speaking from the heart does not legally excuse incitement.
No, but context matters in law. The defense argues that this language was calculated political demagoguery. It was designed to arouse fear in criminals and obedience in the law-abiding public. It was not a literal military directive to cause death, and the prosecution is ignoring how domestic systems actually operate.
Well, let us look at how the domestic systems operated, because the former Justice Secretary, Crispin Ramula, practically admitted that domestic justice is permanently closed for these victims.
Permanently closed is a strong interpretation of the institutional challenges.
He said there are no police reports, no ballistics, and no DNA available. The state apparatus essentially wiped the hard drives of these crime scenes. When the police know they will be protected by the president's rhetoric, they don't bother collecting evidence. That is exactly what the virus of impunity looks like.
Wait, you are making a massive jump from missing evidence to a presidential directive to destroy evidence. And this brings us to the cherry-picking defense, which I think is one of the strongest procedural points here.
Go ahead.
The prosecution relies on a highlight reel. They pulled about 20 speeches to prove this grand theory of incitement to murder. But the defense team went through the archives. They found at least 35 speeches, totaling 45 relevant instances, where the president explicitly qualified his statements.
Qualified them how?
By explicitly framing them within the principles of lawful self-defense. He repeatedly told the police to operate legally. He would say things like, "Shoot them if they fight back," or "if your life is in danger." The prosecution just entirely leaves those qualifiers out.
But does a legal disclaimer in one speech somehow cancel out a death threat in another? If a leader publicly demands a slaughter on Monday and then mutters a caveat about self-defense on Tuesday, the police on the ground still heard the demand for slaughter.
In a court of law trying to prove a systematic policy, yes, it absolutely matters. It proves the policy was aggressive law enforcement, not murder. If his genuine intent was mass extermination, why would he publicly and repeatedly warn the police against abuse?
That brings us to the Pietà speech, which the prosecution highlights perfectly.
Right. This is where the two sides completely diverge on the exact same text.
Because the text is terrifying. He is standing near a statue of the Pietà, and he says, if you don't want to die, don't rely on the priest. He is explicitly telling the public that the traditional safe harbors, like the church, cannot protect you from the state.
But that is exactly what I mean by cherry-picking. The prosecution loves that sentence, but they omit the very next sentence he said in that exact same speech.
Which was a vague warning about abuse.
It was not vague. Immediately after that, he says, abuse your authority and there will be hell to pay, for you will have become worse than criminality itself. The defense argues this flips the prosecution's narrative completely upside down.
I disagree that it flips the narrative.
How does it not? The order was clearly, do your job, but if you cross the line, I will come for you. The defense office literally has a counter, a physical clicker, that ticks every time they find a speech that contradicts the murder theory. They found hundreds of examples.
A clicker in an office does not change the reality on the ground. The phrase hell to pay rings completely hollow when you look at the actual body count and the methodology. The mini Dutertes knew how to read between the lines. They knew the warnings were for the cameras, and the violent rhetoric was the actual policy, which leads us to the Davao model.
The prosecution paints Davao as the laboratory for this so-called killing machine.
It was. The concept of the Davao Death Squad was nationalized, and the transcripts detail horrific specificities about what this unleashed. We are not talking about armed shootouts with cartel bosses. We are talking about the non-Laban cases.
Non-Laban meaning those who did not fight back.
Exactly. There is a documented incident where police claimed self-defense, writing that the suspect resisted arrest, but witnesses saw the man thrown from a second-floor window. He hit the ground, and neighbors audibly heard him cry out Ari, which means ouch. He was alive, and the police just let him bleed to death. There is another case where a husband surrendered, stripped completely naked in the street to prove he was unarmed, shouting, "Sir, I am clean." They shot him anyway, and then arrested his wife on false charges to silence her.
Look, those instances are undeniable tragedies. Rogue police officers committing crimes should absolutely be prosecuted. But you cannot leap from police brutality to a presidential order. The defense portrays the Davao model entirely differently.
Differently than throwing people out of windows?
They argue that he transformed Davao from a communist insurgency outpost into one of the safest cities in the world. And they strongly reject this idea that it was a war on the poor.
How can they reject that? The victims were almost exclusively breadwinners of destitute families living in slums.
Because the administration's broader policy record contradicts it. The defense points out that he pushed massive redistributive policies. He passed tax cuts, expanded the four-piece cash transfer programs, and championed universal health care.
Which does not negate the violence.
No, but the defense asks, why would a man of simple indulgences, a man who ate dried fish, boiled rice, and slept in a bodyguard's hut because he hated elite luxury, why would he simultaneously launch a campaign to exterminate the very working class he was passing laws to help? It does not fit the profile of a man who hated elite oppression.
It fits the profile of populism perfectly. Populism requires a visible enemy, and the drug addict, even if they were just a poor neighbor, became the convenient enemy to rally the base. Furthermore, the death certificates were systematically falsified.
Falsifying public documents is a severe crime, yes.
But it shows a systemic cover-up. Families would receive bodies riddled with gunshot wounds, but the official cause of death would list pneumonia, sepsis, or a heart attack. This links directly back to the president's public guarantee of protection for the police. The bureaucratic erasure of the crime is the ultimate proof of a state policy.
I understand the argument,
But the defense brings up a fascinating geopolitical point regarding the violence. They argue the Philippines is a major transit hub for Chinese cartels. The defense claims that drug-related death rates actually increased after the former president left office.
I am highly skeptical of the causality there.
Well, their logic is sound. If he was the sole engine of the killing, the indirect perpetrator, then the machine should have turned off when he stepped down. The fact that violence spiked suggests the issue is structural and geopolitical, not the result of one man's hyperbole.
That might explain general cartel violence, but it absolutely does not explain naked men being shot while surrendering to state police. But let us talk about the evidentiary link, because I know the defense leans heavily on this.
They do, because it is the most glaring gap in the prosecution's case. The prosecution can't produce a single witness who actually heard the president give a specific order to kill relevant to these charges.
The prosecution's argument is that the order was broadcast on national television.
But in a criminal court, especially at the ICC, that is just not enough. You need a direct nexus. You need a chain of command. Even among the criminal cooperating witnesses, the insiders who turn state's evidence, not one has provided a direct link to a presidential directive.
Because the culture of impunity was the directive.
The defense also points out that the investigation itself is severely contaminated.
You are referring to the P1 witness issue.
Exactly. The defense revealed that a key witness, P1, was interviewed years ago by the current chief prosecutor, when he was still a private lawyer. The defense argues this is classic fruit of the poisonous tree. They imply the investigation was biased from the start, and the prosecutor should have recused himself because he had a predetermined objective to nail the former president.
The prosecution views that as a procedural distraction. What matters to the prosecution is the need to inoculate the country with the truth. They view this ICC process as a necessary historical record, much like the Nuremberg or Tokyo trials.
That is a very dramatic comparison.
It is a necessary one. They want to create a record so that the virus of impunity does not infect future generations. When a leader time travels from the Dark Ages to bypass the supreme human right, the right to life, the international community has to step in.
But the defense cautions that criminalizing political rhetoric sets a very dangerous precedent. Take the word neutralize. The prosecution insists neutralize means kill. But the defense points out that political rivals use that word all the time. If the current administration says they want to neutralize a political legacy, it means defeating it politically, not a literal assassination.
But context is everything. When you say neutralize and 30,000 people end up dead, it is not a metaphor.
Again, 30,000 is the victim's estimate, which is heavily disputed. But the core defense argument remains. Without hard proof that he desired and foresaw these specific deaths, the case relies on spicy gossip. The democratic will of the people, who overwhelmingly supported him, should be respected.
And the victims counter that the domestic system is blocked by the very people involved in the crimes. Confirming the charges is the only way to force the institutions to look in the mirror at the killing machine they became.
So we are left with a fundamental clash. The strict evidentiary demands of international law versus the chaotic, visceral reality of domestic governance.
Exactly. It forces us to ask how we separate a leader's public persona from their legal culpability.
And whether the ICC is the appropriate venue to decode political hyperbole. There is clearly much more to explore in this material.
We will leave it to our listeners to weigh the evidence and decide for themselves if the virus of impunity was a deliberate policy or a tragic perception. Thank you for joining us on The Debate.
Until next time.